and why are you giving it away for free? But we have a different view on this, because we want to make the collection of the Rijksmuseum as accessible as possible, and we want to let the public own the images of the object, and we really want to stimulate creativity. And also we want to inspire the public to do things with our collection and to extend the reach of our collection, because the collection is for everyone. We're here to preserve, research, and present. And also the IP rights, we've got that covered as well. In the Netherlands, and I don't know if it's in other countries as well, I believe it is, but we have a law which states that IP rights expire after 70 years when the maker or artist passed away. And as the biggest part of our collection or objects fits this rule because it's much older, it's relatively easy for us to implement this to our collection. And this is in line with our mission that the Rijksmuseum is for and of everyone. But please note that we do not distribute photos or images of objects when the maker is still alive or passed away less than 70 years ago. For instance, if you look for photos of a well-known contemporary photographer, Erwin Olaf, on our website, you will get an overview of the photos, but the photos are not available to download. Only the photos that are being made in commission of the Rijksmuseum are visible as other agreements apply. Our core belief is that the more people have access to high quality of our collection, high quality photos of our collection, the bigger the chance is that one day these people will come to our museum and visit the objects and see them in real life. Or to speak in contemporary language, we believe in the long tail, even when we know that it's hard to prove with real data. Here I have some examples of what we did with the images. So you can put it on a car. We presented it at the Salone del Mobile in 2013. And the reason why, one of the reasons why we do this is that we really want to stimulate creativity in the broadest sense. And we do this in our museum by giving numerous courses on drawing and other creative forms, but we don't want to limit this to the physical possibilities in the museum that the museum has to offer. By giving access to our online collection, people from all over the world can literally do whatever they want to do with these images. And in a time where digital art and digital possibilities are growing, we want to contribute to inspire creativeness wherever people live or work. Over 640,000 people created their own collection in Rijksstudio. And after the launch, we also organized the Rijksstudio Awards for 6 times, which is a design competition for new arts and products inspired by the images in Rijksstudio. And for us, this is a way to inspire and connect with a young audience of creatives worldwide. This is another collaboration with Heineken, the Dutch brewery, one of our partners, and they made beautiful, I think, beautiful bottles with beer. We use this framework, collection, connection, conversion, because the collection is the heart of our museum. But we want to build a connection with the audience, hopefully to drive them to conversion. And conversion doesn't always mean a financial transaction. Conversion can also mean that people are looking at our content or using our website or doing other things. But the main thing is to build a connection and to keep that connection with the audience. And that's really something that we work on every day, and we always strive for the optimal visitor experience, because that's what we're here for. We have some beliefs here as well. For us, an online visit is as valuable as an offline visit. They each have their own dynamics and customer journey, and they must connect seamlessly, but they both have different ways to connect with our collection. And I'll give you some examples later on. The first example is in Operation Nightwatch. The Nightwatch is the most important painting in the collection of the Rijksmuseum. I see people nodding here, so a lot of you know the painting. That's a good thing. And right now we're working on the biggest restoration of a painting in the history of the Rijksmuseum. And almost 3 years ago, we started with the research before the actual restoration. So the painting has not been touched yet or retouched or anything, but the research already took 3 years. And hopefully this summer we can finish the first part. We still now have a lot of discussion how to continue. And the latest technology has been used in this research. And the first example I want to give you, and I don't know if it's working, but we're going to see, is a high-resolution photo. These numbers here, I don't really even understand what it means, but my colleague told me that it's a very, very large picture, a huge number of pixels. So they used a huge camera to make the most detailed picture ever taken from a painting. And you can see the photo on our website. And I know if I can get to the website. I don't know how that works. Yeah. Let's see. Let's pray. Accept the cookies. And then you can zoom in. Zoom. Yeah. Yeah, you can zoom extremely more. Yeah. So here you can see so much detail in the painting. And this is what we mean with, an online visit can be as interesting as an offline visit. Because this you cannot see when you're standing in front of the painting. If you stand in front of the painting, you will see the whole painting, which is amazing, but this is something that you can only see when you're behind your computer. And when we had the press release this year in January, our visit to the website exploded. So we had so many people going to the website. So if you're back at home, please have a look and go into all this detail. Exactly. The other thing, and now we need to go back. Yeah. Yes. Another thing where we used the latest technologies is the missing pieces of the night watch. Because I don't know if you all know, but 80 years after the painting was finished, parts of the night watch were cut off. Simply because the night watch was moved to another building and it didn't fit on the wall that they were planning that it would be hang crazy. So they thought, let's do it easy. Let's just cut it off. We have never found these missing parts. So that's another part of the extensive research that we want to do. The good thing is that before the cutoff, a smaller copy was made of the complete night watch. And we recreated the complete night watch with artificial intelligence and machine learning. And there's a small movie explaining a bit more about this. Let's hope that this works.
To recreate the missing pieces of the night watch, a computer program is taught to repaint the lundens in the style of the night watch. This is done with a neural network. Neural networks learn by looking at lots of examples. If you give them good examples of a problem along with the solution, they learn to solve similar problems. For the night watch, this was done in a number of steps. First, the paintings were fitted on top of each other in the best possible way. For this, the important points in both paintings were marked with a neural network that can recognize faces and bodies. There are still differences. Parts of the painting will have to be shifted so all important points match up. After this, all figures in the paintings look alike. Only the colors and style need work. For this, we can start training a new neural network. The paintings are cut into thousands of small pieces. These are offered as a problem and solution. The problem is always the lundens, and the solution is the night watch. After learning, the neural network can repaint the lundens in the style of the night watch. The results are amazing. The colors and style of the lundens have been adapted, detail has been added, and the repainted lundens is much more like the night watch. As we can see that the program is good at its job, we can finally ask it to make the missing pieces. The missing parts repainted in style. And the night watch is nearly whole again.
As you can see, both techniques and outcomes have not only helped the researchers and curators, but made the outcomes visible and accessible to a broad audience. Here you see the left is the night watch and the right one, oh, I don't know if you, yeah. And the right one is the London. So you see the difference between the two works. And to give you a small perspective on the numbers, so in 2019, we had 2.7 million visitors offline, so in the museum, and we had 5.9 million visitors online. And when we reopened in 2013, the planning was that we will have 1.5 million visitors per year. And only 6 years later, it was almost double the number. So we need to work on some extra things to make sure that the visitor experience stays very well for all our visitors. So we have some developments at the moment. We're going to improve Rec Studio because it's already now a long time that we launched it. And then we have some other challenges. Yesterday we were talking about the ticketing and crowd control. I think this is an issue for a lot of museums, and obviously there are some new developments, NFTs, metaverse. I do not have the answer yet, but these are things that we need to keep in mind. Well, in conclusion, we strongly believe that digitalization of cultural heritage not only benefits preservation or promotion. For these two things go hand in hand to ensure a sustainable future for our collection. Thank you very much. And I would like to, I don't know if people want to respond now or do it later. Maybe later, yeah, that's probably easier. So the next speaker, and I hope that I will pronounce the name properly, Felicia Caponigri. Perfecto, Felicia Caponigri. I want to repeat it again. The Director of International and Graduate Programs at the Notre Dame Law School.
Yes, thank you so much. May I have
Yes.
The remote also? Thank you so much. It's like, yes, I'll use this one. Well, thank you all so much. First at the top, I have to just say that Notre Dame is very happy to be partnering and sponsoring this conference with the University of Florence. At Notre Dame, we educate a different kind of lawyer for the world, and we participate in dialogue. So I think the title of the conference is most apt. I'd also like to thank Dr. Lucrezia Palandri for her organization, and Avvocato Giacomo Paili, as well as Jennifer Cellani, and everyone else who has participated in the organization of the conference. I'm also happy to have heard Monsignor Verdon speak today, but as I feel with my presentation, I am moving a bit from the sacred to the profane both in my conversation about decoro as well as in my use of images. I ask for the audience's forgiveness beforehand, but I know that there are some attorneys from the Galleria dell'Accademia in the audience, and I've spoken to the Uffizi lawyers, so I'm hoping that we can have a very robust discussion after my presentation as well. So any visitor who comes to Florence certainly will perhaps make their way to the Uffizi Gallery to see Botticelli's Birth of Venus. As they make their way, however, to see what we might call the original version of Botticelli's Birth of Venus, they will certainly be confronted with a number of different reproductions of the famous work, as well as, I've put on the screen, the David. So they'll certainly be confronted with images of T-shirts with David blowing bubblegum. This seems to be very popular at the moment, as well as perhaps smoking a cigarette. Of course, with the Birth of Venus, we have what we might call close-ups on the Birth of Venus, but then, of course, you can also apparently buy an apron where you yourself can project yourself as Venere in your own kitchen at home. So as some of you may know, the idea of reproductions of cultural properties in Italy has been a hot topic lately. And from a comparative US perspective, it is confusing, to say the least. These objects in the US are, well, I should be clear, the intangible compositions that are attached to the unicum of the tangible property of intangible cultural interest to us are in the public domain under US copyright law. And so certainly the use of the composition of the Birth of Venus on an apron, or the, shall we say, simple reproduction, if we want to call it that, of an image of the David seems rather unproblematic. We also, however, in the US, use the term original to describe the sine qua non of of copyrightable subject matter. And so in walking around Florence and in thinking about the recent cases and in thinking about digitization and this panel today, originality, what does that term mean? What role does or should heritage play in our understanding of the term originality? How is originality understood with reference to heritage differently for American and Italian audiences under the law? And how might we understand this term comparatively as we both appreciate on both sides of the Atlantic these objects that are part of our common cultural heritage? So under the Italian Code of Cultural Property Law, historically there has been an article that has allowed public authorities to consent to the reproduction of cultural properties which they hold in their possession. This historically, and the Articles 107 still cites to this, has been seen as a control on the physical, shall we say, touching of the cultural property object to create the physical copy. And in fact, that clause uses original in the article. However, today, that clause is also interpreted as allowing public institutions to authorize the digital reproductions of these cultural properties. Now, at the same time, this clause in Italian cultural property law also cites to Italian copyright law, under which the images of these tangible cultural properties are technically in also a public domain in Italy. And so the intertextual reference, if you will, in Italian cultural property law to Italian copyright law and vice versa raises some questions about how these two legal regimes are to interact. Complicating matters a bit further, we might say, is the recent addition with the reform to Article 108, which allows for some reproductions of cultural properties to be done without the requisite permission and fee from the public authority. So reproductions that do not require any physical contact with the property and are for the purposes of study, research, free expression of thought, or creative expression and promotion of the knowledge of cultural heritage. Such digital reproductions are generally free or are supposed to be. However, the big caveat here is for commercial purposes. So reproductions that are made for commercial purposes still need to have the authority, still need to have permission from the authority, and a fee needs to be paid. We might call this, from an American perspective, a cultural property licensing scheme, as opposed to a copyright licensing scheme. But questions soon appear as to how is it that creative and commercial interact in this space, and what in fact is or might be a creative addition to a cultural property such that it would benefit from copyright on its own, and such that it might be subtracted or in a negative space, if you will, from the cultural property licensing scheme. I recently saw this interpretation of Da Vinci and the Mona Lisa at the Fiumicino airport, and it raises some interesting questions for me about originality as a gatekeeper. What is sufficiently original, or we might say creative, to constitute an autonomous work not subject to a cultural property license? There are two cases, if you will, in Italy that are most on point that might help us answer this question. The first, of course, dealt with what we might term under Italian copyright law as simple reproductions, just the use of the image of the David in publicity campaigns used by a travel agency in Florence, which the Galleria dell'Accademia successfully halted and was able to obtain injunctive relief. On the other hand, there is another case from the Corte di Cassazione, which predates that case from the Galleria dell'Accademia, that allowed a digital rendering of an archaeological object that was used for, that was sold for commercial purposes to be outside the cultural property licensing scheme and subject itself to copyright under Italian law. In analyzing the digital additions, if you will, to the archaeological object, the skull, the court made a number of observations, primarily about how the representative of the company who had created the digital rendering added hypothetical parts of the skull that were not seen because the skull was in the roccia, was in the rock still. In addition, the court noted that creativity under Italian copyright law is not absolute originality, but can exist in small slices, if we might say, that correspond to each author's individual expression. And here we see some similarity with the U.S. perspective of idea and expression. Also in the U.S., ideas are not subject to copyright, but the unique expression of an artist is. So creativity is not constituted by an idea in and of itself, the court said, but the form of the idea's expression, its subjectivity. And so copyrightable works can also be those which take insignificant or minor parts of other works, transforming them and inserting them into a different context, and the difference in expression attributes, therefore, creation to an author who is not the author of the original work or the cultural property. So, you know, from the American perspective and perhaps from the Italian perspective as well, this brings up some questions. What happens when we reproduce a cultural property that is visible completely? What might be sufficiently creative about that reproduction? In reality, at times, the application of Articles 107 and 108 by Italian cultural institutions tend to have a chilling effect, we might say, in the practical space that has not allowed really courts to address this question yet. So some of you may have seen, for example, Brioni's publicity campaign a few years ago for Bespoke, where Brioni used an actual physical reproduction of the David that was made by a workshop in Carrara, and they actually asked their artisans to create a made-to-measure Brioni suit for the statue of the David. Galleria dell'Accademia was not very happy about this, and if there's an attorney here, I'm sure I'll hear about it in the Q&A, but just to say that the Brioni, even before they were, brought to court and seeking injunctive relief, Brioni actually preemptively removed this publicity campaign. So this also gets into a question of relationships between, we might say, the luxury sector and also the cultural heritage sector. Now, of course, complicating matters further under Italian law is a notion that for us in the U.S. is very difficult to circumscribe, which is this notion of decoro. So I assure you that I have put the most safe for work text that I could on this slide from the Wayback Machine. But as some of you may have heard, in summer of 2021, Pornhub created an initiative called Classic Nudes. They took some images from various famous museums around the world, including the Uffizi, and they used this image, so a simple reproduction of Botticelli's Birth of Venus, added some very titillating text, we might say, around it, Pornhub was essentially named and shamed by the Uffizi, because then we can also think about extraterritorial application of the Italian Code of Cultural Property, which would be extremely difficult. And so they were named and shamed into taking down this page on their website. And in fact, if you were to go on the website today, you would actually not find the Classic Nudes initiative at all. Of course, museums in market nations responded very differently to this use of images. So this idea of, decoro is, very much meant to protect what we might say is the unique truth inherent in cultural properties, or the appropriateness, even though doctrine in Italy has called it a bit of a vague term. The idea is that you protect the relationship between the intangible cultural interest in the tangible cultural property, and you allow, what is appropriate to be shared. Now, the Uffizi was able to name and shame decisively the simple reproduction of Botticelli's Birth of Venus, but they chose to not go after the promotional ad recreating, we might say, the Birth of Venus with Cicciolina because of the creative element. This is creative, autonomously. So the lawyers made an autonomous judgment that said, well, that's creative, so we'll go after the simple reproduction. So this gives you a little bit of a framework for these issues under Italian cultural property law and Italian copyright a bit as well. But from the U.S. perspective, it's very interesting because we have actually also, in one case from the Second Circuit, discussed the Birth of Venus in terms of the Venus Pudica. So we do have a case in the United States where Annie Leibovitz sued Paramount Pictures because they created this poster which cited, obviously, to her famous photograph in Vanity Fair, but as part of, shall we say, their parsing of the scope of Annie Leibovitz's own copyright in her expression in this photograph and the lighting and the posing, the court cited to and recognized the form of the Venus Pudica in the Western art historical tradition, and said, even though the basic pose of a nude pregnant body and the position of the hands, if ever protectable, were placed into the public domain by painters and sculptors long before Botticelli, Leibovitz is entitled to protection for such artistic elements as the particular lighting, the resulting skin tone of the subject, and the camera angle that she selected. So here we see that even in the United States, perhaps a bit counterintuitively, we might think, as we're thinking about cultural property in Italy as its own kind of maybe sui generis legal framework, heritage can actually be part of evaluations of what is original expression in a work. Heritage might be an idea in the United States, might be identified as what is part of the public domain and yet informs what we determine to be sufficiently original. Now, just to conclude, to make some concluding remarks, I will say that the application of decoro in Italy also seems at times to be very much a policing of the meaning of new creations. And this can be problematic, especially if we think about it from the American standpoint. Indeed, it is settled doctrine in U.S. law, Blindstein, that judges are not there to make aesthetic judgments. They are not. That is for the art historians. That is definitely not the province of the judge. And yet, I will say that we do have one area of the law in the United States where we seem to be called to at least identify what might be new expression, meaning, or message. And this is in our fair use test. It is the test that we apply when one author takes the work of another author that is copyrighted or copyrightable subject matter and uses it to create their own work. And as some of you may have read, this is now an issue in the Andy Warhol case, where Andy Warhol used the image of Prince taken by a specific photographer and added his usual style. He actually did the same thing with the Birth of Venus also, which is in the public domain, so Botticelli, wouldn't be suing Andy Warhol, but certainly there are some cases in the United States, such as Bridgman and the Meshworks case, which outline, perhaps that there might be a day when certain additions to reproductions of what is in the public domain might rise to the level of being original. And so now this case is up for review at the U.S. Supreme Court, and interestingly, the Second Circuit, in the opinion that will be reviewed by the Supreme Court, made some observations about how simply imposing another artist's style on the primary work, such that the secondary work remains both recognizably deriving from and retaining the essential elements of its source material, is not enough for fair use. And so here they also talked about how Warhol was still depicting Prince as an iconic songwriter and performer whose musical works the public could enjoy and admire, seemingly taking the same or a similar message that the reasonable observer could perceive from the original photographer's work. And so here we might perhaps see some broad similarities, certainly not with the idea of appropriateness or decoro, which is in Italian law, but certainly with some sort of at least parsing of the meaning of a work in order to identify what are the slices of copyrightable subject matter. And with that, I will conclude, looking forward to conversation with my fellow panelists as well as with the public. So thank you very much.
Thank you very much. I think there's enough room for discussion and questions, and but maybe let's wait till everyone has spoken. I was really triggered by you saying Botticelli suing Warhol. That would be an interesting case.
Temporal things as well.
Oh my goodness, how we're going to do that? Yeah.
That's true. Yes, I was trying to make a comparison. Yes, you're right.
Yeah,
Thank
but
you, Giacomo.
very, very interesting. Our next speaker, Lucrezia Palandri. That's an easy one. The floor is yours.
Thank you. Thank you, Marieke. And so it's the first time I don't have to thank the organizers for inviting me. But I would really like to spend one moment just to thank my fellow co-organizers, because I mean they've been such irreplaceable co-workers and humans. So thank you, Dr. Pessina, Jennifer, Alessandra, Giacomo. Viva I tetrarchi. And so I feel that, so the panel was opened by Marieke, describing the extraordinary experience of Rijksmuseum, and that really is at the forefront of the, in opening up access to cultural heritage, and like making its collection freely available since many years, 2012. And then we had Felicia just starting to delve deep into our legal system, inter-Italian cultural institutions such as Uffizi or Galleria dell'Accademia, and that, of course, show a very different policy of access and reuse, and that reflects, of course, our regime of protection under the Code of Cultural Heritage. So I will try, it's a very, very inspiring panel, and I will try to focus on the Italian perspective and to briefly offer, in a nutshell, the Italian approach towards the digital turn, and also mentioning some of the Italian initiatives towards the digital, and especially focusing on the principles underlying the legal and policy measures, and the mindset beneath all of that, and the culture of cultural heritage that permeates our legal system and our society at large. So in doing so, I will try to highlight and to take as parameters some dichotomies that are recurring and that we have been experiencing here during these 2 days, and that are really important to consider when we are talking about digitization as a form of valorization of cultural heritage, as I would like to talk about. And so I would really would like to take this parameter as public and private relationship, physical object versus digital objects, so the original versus the replica, the copy. So also the competing regimes, cultural heritage law versus IP law, and so the subsequent dichotomies, commercial versus non-commercial, and in copyright works versus public domain works, and also more social, cultural, general tension, for example, the one between culture and economics, as we already mentioned these days. So I would really like to focus on the digital turn in the context of cultural heritage, and in particular the dematerialization, the digitization of cultural institutions, archives, and collections. So, taking these parameters when I can, I will not provide solutions and response. I will try to ask as many questions as possible. And so I will start saying what's the general trend. We already know that it's undeniable that, especially over the last decade and even more after the COVID-19 pandemic, the general trend of museums and archives all over the world has been to digitize their collections, their archives, and provide as much as they can online access to these cultural objects, to these assets. What about Italy? Italy, while appunto Italy has been the first country in regulating cultural heritage, and has been long served as a model for other countries that took inspiration for legislation from the Italian law. As far as digitization concerns, Italy is, let's say, late, and compared to other countries, and maybe it's late just because its legislation was the first one, is old, and so its primary purpose to protect cultural heritage was actually controlling and regulating the circulation of cultural heritage. So the idea of letting go of this control, or part of it, that's provocative like my fellow partner taught me, is very far from our traditional mindset, from our traditional approach. Of course, the impact of the pandemic has led to an acceleration towards the digitization of collections, and surveys by the Digital Innovation in Cultural Heritage and Activities Observatory of the Politecnico di Milano, in Milan, show that while in 2020 there were 40% of Italian museums offering digitalized collections, by the end of May 2021, there were already 70%. So notwithstanding this number, these percentages, the main problem that seems emerging from this observatory's research is how to make these resources not just mere repositories of files, but usable, efficient, interactive archives. So as Lorenzo Casini explained perfectly this morning, valorization has been later introduced in the code as an additional function to be performed by both public and private institutions. Public as the duty to perform, and private as may choose to perform such activities of valorization. And on the one side, to promote knowledge of the cultural heritage, and on the other side, to ensure the best conditions for the use and public enjoyment of such assets. So digital collections and archives should be first known and later activated. The introduction of the valorization function has profoundly changed the nature of cultural institutions in general, both public and private, because they're not only seen as such repositories, such dusty repositories where to store and preserve, but they're seen as living institutions, as Professor Casini said this morning. And this just gives me the chance to mention a project of the Department of Legal Sciences in collaboration with the Department of Architecture and Design at Florence University, entitled Living Archives, New Methods of Dissemination and Reuse for Fashion Heritage. So with particular reference to textile and fashion archives, the project starts from the premise that nonetheless it's self-evident, as we've seen, that digitized cultural objects may be potentially system open to multiple use, reuse, and interpretation. Such digital archives not only do not find sufficient response among the general audience in terms of consultation and use, but are often not even known by possible recipients. Therefore, Living Archives project aims at investigating the role of archives today and developing its potential, devising new applicable solutions to encourage the dissemination and reuse of material for research, educational purposes, and as a source of inspiration for designers or creatives in general. For this project, we decided to adopt an interdisciplinary approach, just thinking that it's crucial to have different competencies, different skills to develop efficient and new models. And of course, we need the designer's competence to operate with a design-driven approach and identify the context of use and the possible meanings of the digitized material. And on the other hand, we decided to resort, of course, to legal expertise that can investigate and define the most appropriate legal frameworks and rights statements. At this point, I cannot not mention the open access movement. Even in Italy, the debate around open access policies has started raging also amongst Italian scholarship and cultural heritage professionals and public opinion in general. But is there any Italian institution that has adopted such policies? A few. There is Museo Egizio in Torino, and there is Fondazione Torino Musei, still in Torino, which not by chance, of course, are private foundations. And a recent found out that I didn't know, only one public museum, public institution, which is the the National Museum of Matera in Basilicata, southern Italy. Yeah, and that was really struck me. And of course, it's only for a part of the collection, the Rizzon collection, that includes 74 digital reproductions of pottery vases that are available online under the Creative Commons licensing scheme, CC BY SA. So one of the most open Creative Commons licensing. Of course, the discussion in Italy around the open access movement is part of the broader debate on free reproduction of digital images. So if is it possible to rebalance the IP framework, which seems such a strong myth here in Italy. And the debate started in 2014 with the art bonus decree. I won't spend time on it because it's been already mentioned. And then we are in the process of implementing the EU directive on copyright, 790 of 2019, and in particular Article 14, advocating for the free reproducibility even for commercial uses. So just eliminating the dichotomy between commercial and non-commercial uses. So the general debate seems shifted. In the first phase, there was the question of which types of limits on reproductions. And now, probably the question is more whether there should be limits at all. Very active are private associations, private organizations, such as ICOM, Wikimedia, Creative Commons Italia, and they also they were at the Senate for an audition, and that was just collected. And ICOM Italia, for example, did an amazing job on guiding lines on how to increase the level of public access to cultural property. And then I would like also to mention another association, which is very specifically devoted to fashion and the heritage of fashion, which is the European Fashion Heritage Association, which is also involved in the Living Archives project that I mentioned. And so the European Fashion Heritage Association includes 45 cultural institutions that make their collections available online. And European Fashion Heritage Association is kind of an aggregator, a platform that connects these cultural institutions to Europeana, which is this European portal that's one of the first initiatives from the EU in incentivizing the digitalization. Museo del Tessuto, Textile Museum in Prato, is part of European Fashion Heritage Association, and Museo del Tessuto is a private foundation. I would like to mention it because even if still their collection, they're working on the digitalization, and they're planning to put online 3,600 objects, essentially pre-industrialized objects, and they are planning to make them public, not for commercial use, but with a broad CC license. Probably, I just talked to the responsible, the CC BY NC SA, which is like sharing with credits, and which implies that it must. I mean, for commercial uses, they need a request. But the value, the special value of Museo del Tessuto, Textile Museum's work, I think resides in actually promoting and creating this European network and trying to unify standards with other European cultural institutions, and to start and open up a conversation on such standards. I'm studying Merriman too. I cannot avoid, of course. I try to keep it to the minimum, but I'd like to cite one of his seminal articles of 1989, which is The Public Interest in Cultural Property, where there is a specific definition of access to. The public interest is like allowing the relevant public to access cultural heritage. So the widest possible public should be able to see cultural objects owned by the institution. And even with this word owned, we could also talk about as the role of museums and cultural institutions, not as owners, but as guardians or custodians and not gatekeepers, in a sense. But what does it mean? What does Merriman mean with this definition? Actually, access, especially after the technological turn, has many different ways to be implemented and many diverse levels of engagement and of access, actually. So from the simple fruition, the mere access, the visit, the consultation, to new ways of active participation. So an active engagement by the private individuals and associations. I would like to open up just a couple of questions. I had more questions, but I have 2 minutes, so I will just cut to the chase. And so are we sure that we know what does access mean? So is there only one interpretation of what are the best conditions for the fruition and the enjoyment of cultural objects, ex Article 6 of our code? Of course, we mentioned also during the roundtable this idea of cultural property as very Western-based, and so I will just say that digitization can also change this approach, change this perspective. Technology, as also Derrida says, can change power relations, and even ordinary people or even minorities or even indigenous groups can also be heard and have the ability to influence existing content by adding their own or by being consulted by cultural institutions in recollocating and rethinking their collection in the moment of the digitization. So I will finish here, and thank you for listening, and I will be available for questions.
Thank you very much, Lucretia. It's obvious that we need a lot of time to discuss this properly because there's so much ways to look at it. Our next speaker, Barbara Passa. The names will get easier for me, so that's perfect. Professor at the University of Venezia.
Yes, thank you very much. Let me thank the organizers, of course, just to say thank you, Lucrezia, and Vittoria, and Alessandra, and all the other organizers. So thank you very much. It's an extraordinary chance to be here, just to start this dialogue, to set the stage, as you said yesterday. So thank you very much. Probably I need thank you. Okay, I try to follow these slides because it's easier for you to follow my thoughts. So. What we do in Venice is focusing on the challenges encountered by cultural heritage institutions when opening up their permanent collections and archives vis-à-vis the creative and creative reuse of heritage by this different typology of people: established artists, would-be artists, workers in creative industries, people who post user-generated content on the platforms. So we asked this basic question: is there any reasonable notion of accessing cultural heritage, one that can substantiate new opportunities and not just threats? Our goals are to connect or maybe reconnect cultural heritage institutions with cultural and creative institutions, increase participation of small and medium enterprises, engage citizens and society, as they say yesterday and today. How can we do to engage people to enjoy cultural heritage? So another goal was to support new forms of cultural and artistic expression built on existing tangible and intangible heritage, and to contribute to the Sustainable Development Goal, saying that reuse, remix, reproduction, appropriation means also be in line with sustainability under certain perspective. Then the ultimate goal was to imagine new professionists, hybrid curatorial and archival figures, able to move sensitively within these two main sectors. Okay, so this is the general framework. So our research builds on observation, case studies, interviews, desk-based research. The project is a research and educational project. We launched our university, and the content is mapping out the legal and policy measures adopted by major cultural heritage institutions in Venice. Today I present only two of these, the MUVE, the Fondazione Musei Civici di Venezia, which is a private entity as a fondazione, but the participant is public, the Metropolitan City of Venice, which is responsible for 11 Venetian Museum, as probably you know, and it boasts an immense cultural heritage, and you can access to this heritage through the Catalogo delle Collezioni database. And the second example is that of ASAC, the Historical Archives of Contemporary Arts of the Venice Biennale. Once again, a huge catalog, multidisciplinary and multimedia structure, which includes all these collections: historic fund, photo library, film library, media library, artistic funds, and poster collections, so forth, so on. And you have also here the ASAC database. So this is the catalog of the collections database, and these are the 11 museums, from Palazzo Ducale, Museo Correrca, Pesaro, Carezzonico, to Museo del Merletto, Museo di Storia Naturale. And this is the ASAC database, and just a few examples of what you find inside this database. For example, poster, very important poster, the inspiration for many designers, for example, or artists, so it's a rich database. So the engagement of art and architecture and design students in this research and educational project has been of utmost importance, precisely because, on the one hand, they produce the protected material that is the heritage of the future. So this idea of transmission of our cultural heritage, which emerged yesterday as well, at the same time, they are inspired by the works of others. They are inspired by this cultural heritage we share. So it means that they are inspired by other artists, by the works that belong to the museum and that belong to archive collection, to the database, also in the digital sense. But they want to copy and appropriate all this material. They want to reuse, adapt, and change the material for their own creation. So, of course, they ask themselves and they ask to us, is there a meaning of access compatible with both the preservation and promotion of cultural heritage on one side, and with the traditional idea of protecting others' rights to what they create, and with the necessity of sustaining being young people, students, Gen Z and Gen Alpha, the digitarian, as you know, they ask for sustaining them as authors, because they have no bargaining power. So just to be clear, every author is an early author and then a later author, and all these categories probably needs protection. So our starting point was, is it possible to go for the reproduction in situ of tangible materials belonging to the permanent collection of this cultural heritage institution? And is it possible to reuse the digital material? Okay, questions, students and researchers and colleagues of mine, because I teach law at the Architecture and Arts department in Venice. So, yeah, not only judges and lawyers, we discovered today, they don't know legal rules, but of course, these people, they don't know legal rules. So, of course, they ask many, many questions, starting from the idea that culture is something historically produced as unbounded rather than bounded, as contested rather than consensual, as incorporated within structures of power, rooted in practices, symbols, habits, patterns of practical mastery, is negotiated and constructed through human action rather than superorganic forces. So this was our common background, and then came these questions: how to facilitate the use of the reproductions contained in the digital archives. Would be advisable to consider including in online databases clear policies and examples of how the latter can be used for personal and commercial purposes. How to facilitate personal reproduction and the use of objects and sites deemed to be of cultural interest for artistic, historical, archaeological, or anthropological reasons. This is the definition of our Italian code. How to know whether work is out of copyright, for example, public domain. Why a work resulting from transformation and adaptation of an original work, but without altering the original sense of it, is defined as a derivative work and must be authorized by the author of the original work, and so forth, so on. So many, many questions. Students, for example, they make this kind of transformation, as you know. This is a photo they take from the Archivio Progetti at our university, and they reinterpret it. So it's always a question of reinterpretation. This morning, this word came out. So they, for example, want to do this collage and remix, and they want to go on with this kind of engagement with traditional cultural expression as well in the field of fashion design, for example. They know that every cultural unit has been transformed in information by the process called datization, so they're perfectly informed about this possibility because it's easy to reproduce, reuse, adapt. But what we did is also to collect all these rules, and we realized that a combination of different rules prevent us from fully accessing our cultural heritage, even when the works are in the public domain. So this is a sort of granular approach, granular in the sense we really went into details to collect all these rules. So you find contractual clauses, website terms and conditions, for example, and other contractual arrangements. As you know, let's take Facebook and YouTube, for example. Intellectual property rights claims, first of all, copyright claims, but also IP rights of third parties, for example, the author of a database who created it and the maker of a database, the photographers, within the two categories of simple and artistic photos, for example, and so forth, so on. Privacy and data protection rules, you find also this limitation. Regulations governing open data and use of public domain information. Of course, our cultural heritage law, and yes, here you find these two articles that Felicia already quoted and explained. And other model provisions elaborated by UNESCO and WIPO for the protection of expression of Florence, so forth, so on. So really a mass of legal rules. Of course, we concentrate our attention on this intertwining of private rights and public interest in artistic and historical preservation and promotion, and the intricate interplay between cultural heritage law and copyright law. Because this intricate interplay raises many problems. De facto, this regulation imposes many limits on artistic, transformative, and commercial reproduction and reuse, also for works of visual arts in public domain, as you know. So the point is that it's not always clear whether a cultural heritage institution is claiming the application of legal cultural heritage rule, or whether it's instead invoking copyright law as a privilege to allow or discourage the reproduction and reuse of the permanent collection, their possession. Just to remember that, at least in Italy, cultural property means basically everything. So our students, well, you know, that is astonishing, Professor. Everything is in the cultural property, so we must ask authorization for everything. Yes, all immovable and movable things possessing this artistical, historical, of course, when they are qualified as cultural interest, but also works made by non-living authors between 50 and 70 years ago can be declared of cultural interest, along with works by non-living or living artists produced more than 50 years ago, if they hold an exceptional interest for the integrity of the Italian cultural heritage. So they said, okay, we can't do anything. Okay, we leave it our faculty because we can't do that. Okay, no. So the other possibility was and is to look at this open plan movement. So Lucrezia already explained everything. We know that they adopted a proactive approach. There are a lot of CC0, CC BY 40 license. So yeah, I would say 3 or 4 cultural institutions are part, Italian cultural institutions are part of this open plan movement. We are not like the Rijksmuseum, unfortunately. But the point is this. Take, for example, Europeana. Well, with my students, the future artists and creative, blah, 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 we have a look at this, and they say, okay, but all these foreign rights statements are not intelligible, are not easy to understand for us. So this is a sort of resume of what we find. So we find this CC0, all these Creative Commons licenses, and these rights statements that Europeana added in copyright, no copyright, or uncertain copyright. So it's really difficult to understand for non-lawyers. And this is incredible because, yeah, I would say to me it's difficult as well. Just to follow this scheme. Don't you think so? It's not easy to understand. And this is the elaboration by my students, Elisabetta Crepaldi, Sacchini, Vendrame. So yes, of course, you find some platforms, websites, where they try to provide information on all these things, but it's not easy. So we go straight advocating for reuse in the cultural heritage sector, for a new sensibility in working with everything we find around us, from monuments, spolia, paintings, documents, everything. Reproduction, reuse, remix. We took inspiration by this Broker book, Words of Reuse, Manifesto, which is really a nice book. Manifesto, small manifesto, yes. And we produce our glossary. I go really quick there, but let's start with reproduction, for example. We think that today there is a neurosis about being original, because the fear of being seen to copy may stop good idea taking form. So we feel, I mean, I'm here interpreting the feelings of my students, the oppression of originality on authorship, and the tyranny of invention, which may go back, by the way, the history of things, because our material culture is really based, rooted in the copy. So, and moreover, copia as also another meaning, means plenty, abundant, as cornucopia demonstrates. So we went on writing and thinking about all these words, just to set this new stage about practices of reproduction and reuse. just fighting against what they call the culture of permission, meaning that without authorization and payment to the cultural institution, they can't do anything. These are the articles of cultural code that you already explained with this link to the copyright law provisions. So it means really to be stuck. I present only one case, though I give the rest to my paper, and so I invite you to read the paper. The case is about the Natural History Museum of Venice, a group of art students of our university, founders of a collective of contemporary visual arts named Lab, write to the Natural History Museum, as you see, to ask the authorization to produce videos and photographic materials within the museum in order to create an audiovisual work which combine artistic and documentary imaginaries to be distributed in galleries, festivals, and other cultural events. To this end, they requested access to the Reali and Miani collection. Here you see the picture of one of these collections. The problem is that these collections have not been digitized by the museum and are not visible except by going there and by reproducing there. So they ask about the fees charged by this museum for the rights to the images and the videos and they wishes to produce. This is the reply of the Natural History Museum. Please fill the form. So just fill the form. What is the scope? Research, illustration. What else? Artistic. Is it commercial? Not commercial. Basically, artistic means not commercial at all. Looking at this Google form, because commercial is on the on one side and didattico, scientifico, and artistico on the other side, and many other things. In any case, you have to pay. So there is a tariffario for digital images, but nothing for the video shooting. And also here you discover that if you are a student, you must be a young student, under 25 years old, because unless you have to pay normal fees. And in any case, for the digital images, what students found in this database are few stones, nothing else. So, I mean, these two collections are not digitized. So, they continue to say, okay, the payment of the fees depends on the purpose of the video shooting and on the need for additional guidance during the stay at the premises. Then they said, the only parameter that affects the price to be paid is the total hours needed for filming. And in any case, a discount would be applied with respect to the commercial use, given that your purpose is artistic. In any case, the final price is this, 1,200 euro. So I have a lot of different examples, the second part of what you will read in the paper is devoted to analyze the transposition of the copyright directive, and here you will find another granularity. We will put some meanings of reproduction, at least that we interpreted it, and the transposition of the Italian articles of the directive. Also, in respect to normal people, citizens, and other institutions which are not cultural heritage institutions, you will find a sort of a framework of the article of the directive and the Italian transposition, just to see whether it's possible to do transformative things to appropriate. And then we just produce a sort of case law book at the end, just collecting Italian judgments on some let's say, important concept about parody, caricature. So you find some judgments of some courts, not the Supreme Court, but also not only the Supreme Court, also Court of Venice, Court of Milan, or Florence, on public domain, for example. Some ideas what our courts think about that. On fair use, yes, you said about this fair use, and of course, what you find is that Italian judges are following the fair use doctrine. They quoted these precedents in this sentence. So actually, we are following this idea. That would be a lot of things to say also on these purposes of scientific research. This is a really recent Cassazione Civile Supreme Court judgment on the Archivio Mario Schifano, Eredi Mario Schifano versus Fondazione and University of Genova. It means that they are going also against the universities. So, yeah. The conclusion is that we need to empower people to explore and respond to our cultural heritage in new ways that our legislation has yet to contemplate. And we need to involve younger generation, cultural heritage institutions, and cultural creative industries to work together. So thank you very much.
Thank you very much, Barbara. And the last but definitely not the least speaker, Sonia Kachel, professor at UC Berkeley School of Law. A foreign perspective. I'm very curious what you have to say.
Thank you. No pressure. It's great to be here. Thank you so much. Wow, thank you. It's great to be here, and wow, what an amazing series of presentations and just the discussions that we've all been having today. Oh, sorry. Yes. Okay, sorry. It's really wonderful to be here with all of you, to have these conversations in such a fantastic place and venue. So I just want to start by offering a very sincere thanks to the organizers and the speakers who have been part of this just extraordinary dialogue. So I want to, this term, techno-heritage, is the title of an article that I'm going to be talking about today. And I want to kind of start off with a story that really, I think, explains sort of why I found this issue of kind of cultural property and intellectual property so interesting. And this is because, so the story is that a few years ago, two artists, some of you may know this story, one that was armed with a surreptitiously hidden scanner under a scarf, walked into the Neue Museum in Berlin. And in clear defiance of the museum's very strict no photography rule, they walked out after garnering a 3D scan, they claimed, of the famous bust of Nefertiti. And the artist then titled the resulting product The Other Nefertiti, and they claimed that it was a perfect replica of the original. And then they released the scan online with the Creative Commons license, which we've heard a great deal about throughout this conference, so that anyone could download and then replicate the bust for their own purposes. And their project had two motivations. One was to display their own 3D printed version in Egypt as a statement against the theft of cultural properties by Western nations. And second, to protest the strict limitations that museums often place on sharing the informational data regarding their works with the public. And so this was their project. It got a lot of attention. And then ironically, a few weeks later, the whole story was revealed to be essentially false, right? It turned out that the scan that the artists used, it seemed, was actually most likely a scan that came directly from the museum's own archives itself. But the purported falsity of this story, I think, only further underscores the value of what these artists were trying to say about the relationship between technology, cultural artifacts, and the notion of private property. While precise digital imaging of such politically and emotionally fraught cultural properties such as the Dead Sea Scrolls and the Elgin Marbles have not stilled the protests about their legalities of their current physical possession, one expert, Neil Silberman, has written, they have nevertheless created a new kind of cultural property, a kind of meta-cultural property that represents a shared global culture that we are creating today. And that's kind of the theme of the talk that I wanted to give today. So today's museum essentially has been made possible by an explosion of digitization technologies that can precisely replicate pieces of works of art and make them available to a wider audience. And these technologies, of course, have never been more striking, particularly in an era of news reports that are continually punctuated by images of how cultural properties have been destroyed by war or by climate change, all of which threaten these iconic works of art. So today's era, I think, can be kind of characterized by this really interesting kind of overlapping set of themes. The first involves the consistent eruption of outright destruction, right, due to war, due to climate change, environmental changes, and this obviously reduces the pool of available antiquities for public viewing and appreciation. But the second, and the almost conflicting pattern, is actually one of marked mass redistribution. So at the same moment that we see an endless array of attacks on cultural property and antiquities, we also see a tremendous explosion of the availability of their replication. So one theme contracts the pool of cultural resources, and the other expands it. So with the advent of 3D printing, mapping technologies, other sophisticated forms of information technology, the preservation and the replication of antiquities has never been easier. And yet at the same time, the more that these cultural properties become digitized, the more likely it is that copyright law, with all of its restrictions and limitations, will rear its head. And that is exactly why the Nefertiti episode is so revealing. And I should say that this image came from an actual store in Florence that is selling this image, so you can come up and ask me and I'll tell you where to get it. And it raises really interesting themes, right? Themes of cultural property, but also themes of colonization, themes of repatriation, and open data. And it also raises questions of representation, interpretation, and misrepresentation in the same extent. So these questions, I think, demonstrate, to a kind of unbelievable degree, the limitations and the possibilities behind the marriage of technology and cultural heritage. And this is the term techno-heritage that I like to use. So just as technology has the power to preserve and protect ancient artifacts, it also invites a dizzying array of legal conflicts over their digitization, particularly regarding the intersection of property, copyright law, and cultural identity. And the more interesting question, I think, is whether these potential disputes are reruns, right, of other debates that we've seen, or whether there's something new here that we haven't anticipated. So this talk is really about that question, right, the limitations and the possibilities of techno-heritage. And let me start off by talking about a statement that was made back in 1947, when André Malraux, who was France's first Minister of Cultural Affairs. He was also a former Gestapo prisoner, an art critic, a novelist, and a freedom fighter, very busy man, talked about a concept. And the concept that he used was this concept of museum without walls. And the idea was both simple and beautiful. Photography, he wrote, had made it possible to view art that was suddenly free of context, pulled from its location and its historical origin. And by freeing art from its geographical and temporal identity through reproduction, Malraux predicted that the viewer could essentially curate her own experience, viewing art from Africa next to art from Europe, or by inventing her own themes of selection and arrangement. And we see some of this today, where we see a tremendous explosion of the technologies to produce the duplication of images and the ability of the consumer to curate her own experiences of art, selecting and arranging and creating on her own. Now, for a long time, as we know, museums have been excited about digitization, but it has also presented them with a particular paradox. Digitization and technology represents new ways to reimagine the museum, but they also render it less relevant because of technology. So how do museums remain relevant and financially healthy in the age of new technology and digitization of content? How do countries and cultural properties remain relevant, one might say authentic, in an era of multiplicity? And then there is also a great deal of questions that are out there, a great deal numbers of questions that are out there due to the rise of interactivity. So in the paper that I wrote, I talked about 3 different models of interactivity. And what's so exciting about this conference is that we've touched on all 3 of these models. The first model is an extractive model. And that is a model where a user accesses materials from a database and can essentially create a museum without walls to curate her own collection. And it's extractive because it enables the user to pull materials from a central source of material. And the second model I call immersive, and it describes these projects of kind of virtual reality or augmented reality. And this basically enables the user to kind of enter into an environment that is defined in some way by technological capacity, to replicate the sensory feeling of being in a new environment and providing information to the consumer. And this is not always about, so here's a model of the extractive model, which I just took from the Brandywine Museum, which has a project that it titles Curating a Collection, Make Your Own Museum at Home. And you can actually print out their catalog, right? Cut it up, and then rearrange it, right, using art from the museum. And so they have this whole project where they encourage kids to do this using dolls and creating their own diorama of a museum, which I think is quite brilliant, given that I have sometimes very bored children at home who are 7 and 11. But the other image, right, is another kind of extractive image, and this is a famous painting by Leotard that was also presented to my daughter at school, and they said, why don't you recreate this painting? And this is my daughter recreating this painting, right? So another, I'm sorry, I am a proud parent. I will use every opportunity to showcase my children. But this gives you an example of how you can kind of make art more relevant to children, right? And then there are also these incredible immersive projects, right? Like this UN-produced film called Clouds Over Sidra, which is made to actually draw attention to the plight of Syrian refugees, right? And so again, it's not just about commercialization, it's about emotion, it's about stories, it's about allowing people to connect to different kinds of narratives that they wouldn't normally be associated, that they wouldn't come into contact with. And that is just what a museum is designed to do, right? And the third model I describe as derivative, and I call it derivative because it allows users to kind of create new objects, potentially commercial objects, from scanned data sets. So as we know from the speakers at this conference and elsewhere, many museums are digitizing their collections in order to offer greater access to the public, right? And because the technology allows for minimal physical contact with the actual object, antiquities can be safely preserved and yet documented with precision, right, which was the example that we saw earlier. And since only a small percentage of a museum's collection can be available to the public at any time, museums can now print high-quality replicas for additional viewing at another site. And museums have opted to digitize their collections, not just for archival purposes, but also to encourage others to view, to remix, to 3D print. And I just want to say for myself, the Rijksmuseum has been such an inspiration. Like, I have followed this museum for a decade because of its choices, right, in terms of opening up its collection. So it's really an honor to share a panel with you. But other museums, taking this as an example, have created other opportunities. So the Sculptor Hall Basel Museum in Basel has a 3D printing expert, had an expert digitize its collection of high-quality plaster casts of Greek and Roman sculptures in order to make the digital files available for anyone to use on the web. And in San Francisco, the San Francisco Asian Art Museum has held scan-a-thons where they actually, I mean, this is so cool. They invite members of the public to use their camera to photograph objects from different angles. And the photos are then fed into a program called 123D Catch. It's a computer program that uses the crowdsourced photos to build a three-dimensional model, a scan of the object, enabling others to print from the scans. So this is an example of an iPhone case from an ancient work that was using this technology. So clearly the replication of these items of cultural heritage are priceless in their possibilities. But at the same time that information technology enters the public and the picture, so does the legal ability to control through themes of property, which is kind of like fitting a square peg into a round hole. So every time someone makes a copy of something, whether through a photograph or a 3D printer, they often unwittingly, whether they realize it or not, bring copyright law into the regulation of their creations. And so while normally we think of copyright law as a good thing for artists because it helps them to profit from and to recoup from the cost of their creations, it can be a bad thing, as we've seen, for the public who wants access to their goods. And the more interesting question, again, is this something new in the museum context, or are these similar kinds of questions that we've seen elsewhere? What I think is new about these kinds of issues is that I think that this signifies to me the dangerous conversion of cultural property into intellectual property. And the difference between the two, the difference between cultural property and intellectual property, I think really underscores this complicated intersection between property, identity, and ownership. So we know from the Hague Convention, right, the UN document that governs cultural property, that cultural property is a broad umbrella term that denotes both movable and immovable property that carries great importance to the cultural heritage of every people, like monuments, archaeological sites, buildings of historical interest, works of art, literary creations, scientific collections. But because this term is so broad and it encompasses all sorts of facets, property and identity, it gives string to a number of different kinds of conflicts. So all of the same issues that we see in other contexts regarding the intersection of copyright and technology resurface in this context, but the failure to recognize the distinct difference between cultural property and intellectual property can often lead to problematic results. So cultural antiquities, right, in this context are mostly tangible things in contrast to intellectual properties, which are also non-rivalrous by nature. But the thingness of an item of cultural property is what creates this kind of conflict. So at one point, the CEO of the J. Paul Getty Trust, James Cuno, said, he talked about the stubbornness of objects. And what he said was, it's not the same with music, it's not the same with film, it's not the same with literature. But when it comes to physical objects, these things are kept as evidence of a proud past, as defined by the nation-state government. And as an intellectual property scholar, Peter Yu has explained, cultural property laws are maintained or motivated by a desire to retain, to repatriate, to reserve, preserve, protect, and authenticate tangible artifacts of cultural heritage. But in contrast, the guiding focus of intellectual property, right, is almost always touching on notions of profit from replication. And it involves the notion of replication, control over replication, the control of commercial exploitation, reproduction, and distribution, and also motivated by a desire to protect reuse, to protect innovation by allowing the preservation of building blocks of raw materials for future creators. And so that's why we have protections in the US, like fair use, for the purposes of remix and reappropriation. But by digitizing and replicating cultural properties, however, they become converted into an item of intellectual property, and their owners often fail to realize or recognize the limitations of copyright law's control. So what happens in this kind of situation is museums might use contractual provisions to limit access to visitors unless they promise not to scan, photograph, or replicate materials. And this happens, as we all know, even when these materials are in the public domain and might be subject to fair use protections. So a colleague named Jason Mazzone has written about the phenomenon of copy fraud, right, which happens when a user asserts copyright protection in elements or creations that are actually not copyrightable in order to control access to an object. So here are some examples. In the late 1980s, researchers discovered a series of human brain fragments in Morocco. And they used laser scanning, magnetic resource imaging, and CT scans to develop a data set of the composite skull image. And they had them stored at a museum in France, which essentially stored the fragments. But the museum and the Moroccan government both claimed a copyright interest in the data sets, the laser scans, the magnetic resonance images, and the CT scans. So although they allowed researchers to use the data sets to create a composite image of the skull, they both required that the data sets not be made public as a precondition for access, even though the skull image was eventually published. And there's another example that I'll share with you. Long ago, a group of archaeologists that were working with a grant from the European Community attempted to digitize government photos and imaging data from a Greek site for the purposes of producing a kind of interactive compact disc. But the Greek Ministry of Culture refused to allow them to digitize their photos or imaging data because they claimed that there was a copyright interest in the material. So the researchers said, okay, so then they attempted to gather their own images and data without relying on the government's material, and then they were essentially banned from entering the site. Right? So the phenomenon here of copy fraud illustrates a kind of structural dimension to the intersection between tangible and intangible property. Most antiquities are way too old, obviously, to be copyrightable, of course, and so they're in the public domain. But their 3D scans are also not thought to be independently copyrightable because a creator cannot show creativity in making the copy. So in one representative case of this from the United States, mentioned earlier, a court held that no originality was shown by developing slides from paintings because the photography was sort of meant to, quote, reproduce the underlying works with absolute fidelity. So when the scans involve mechanical reproduction rather than originality of thoughts, the scan under copyright law did not deserve protection. But despite these limitations by copyright law, many governments and owners still rely on copyright law in order to control access to these works. And then there's also another issue. So at the same time that we might be concerned about taste-related or remix-related limitations on reuse of cultural properties, we also have to be really mindful, especially in the United States, in areas where technology historically has tended to obscure the interests of indigenous peoples who have often been used as both objects of study and had their sacred artifacts misused. So as one colleague, Angela Riley, has observed, unauthorized reproduction and distribution of indigenous cultural property can be one of the most significant issues that are faced by indigenous communities today. So sometimes the materials are meant to be kept secret. Other times they're meant to be used only in a certain manner and by certain individuals. And so here we see another conflict in the United States and elsewhere. So while the community of open access advocates have often, and rightly so, chided museums for their restrictive policies, many members of the copyleft community have often tended to overlook and discount the very significant concerns that are raised by indigenous communities with respect to the digital dissemination of traditional knowledge. So on one hand, digitizing items of cultural heritage in many other contexts promises this incredibly powerful way to reconnect with the past and build greater collaboration between technologists, indigenous communities, and museums and libraries. So technology and new media can represent enormous potential for widespread user interactivity. So within indigenous communities, we've seen examples where 3D projection systems have been used as a powerful way to connect elders, older individuals, to their past, creating a kind of emotional connection with objects, and creating a world that is just important for them emotionally in the virtual world as one feels in the physical one. Oh, sure, sorry. Let me just move forward. So these are just some examples of examples where people have digitized members of aspects of a particular collection. This is an example from the Smithsonian where there was a repatriation of the actual tangible object and then a replica made. And the thing that I just wanted to sort of emphasize by these examples is that just as others on the panel have mentioned, there's been a real desire that is new, right, on behalf of museums in the United States to integrate the concerns of indigenous communities. And the last thing that I just want to say is I just want to end with kind of I think a really great quote from someone named Kimberly Christian, who has talked a little bit about creating important protocols around these works. And what she says, and I'll just end on this, the choice is not between an open or closed anthropology. Information in the digital age supposedly wants to be free. What these projects offer is a view of information not as wanting to be free, but already as part of ethical systems in which it wants to be responsible. And so I would just end with just saying that I think that this is the challenge, right, is how to balance intellectual property, cultural property within an ethical framework that really takes into account communities who have been disenfranchised from these systems. Thank you.
I can imagine that there are quite some questions from the audience. So I would like to start if somebody wants to say something or ask something. Yeah.
Thank you. That was a wonderful panel, very informative. Thank you. I'm Diane Modestini. I'm clinical professor at the Institute of Fine Arts of NYU, and I teach conservation. The issue of in conservation of technical images of various sorts has become of great importance lately. There are many more different types of imaging that are available, and it's rapidly increasing. These images are tools in the way that photographs were for Malraux, that students, particularly advanced students, but also younger students, can use to study works of art and come to their own conclusions about them. When the pandemic started, we closed down and I was forced to move my studio class online. And I started looking around. I mean, we have some of these images ourselves, but we don't have, for example, an XRF scanner or an XRD scanner, because they're very expensive and very few institutions actually have them. But I wanted to find some images to show my students. And there were very few museums that make these available to the public, even show them on their website. A very large American museum, which I will not name, you cannot even find an X-ray. So other museums have made a great effort to make this material available. And I think that the trend is in that direction. But there's another aspect to this that, well, it's a little difficult to point out, but human beings have a natural interest in protecting their own information. And the people who work for the institutions that make these scans and have access to this expensive equipment really don't want to share them, because it gives them power to be the only ones who can have this information, interpret it, and so on. Once they've done the work, once it's published, once it's been presented at several conferences, fine. I think after that, they should make it available. And I don't really think there's any excuse for them not to. So I'm going to, now that I'm kind of semi-retiring, I'm going to make a little crusade about this. But it's because it really does put students, and especially advanced art history students who don't have access at a disadvantage. And just because you have made this scan and you have studied it doesn't mean that somebody else from outside your institution who has a very particular knowledge about something cannot find a different interpretation or more information that you didn't think of. So that's what I have to, and I know that the EU has a new incentive, a follow-up to the Charisma project, which is to digitize images. The hub is Florence. Florence has not been the most outgoing place about providing technical images. If you go there, they'll show you, you can look at them on a monitor. And then it's supposed to have spokes out to other European countries. I don't know, I can't find it online anymore. I don't know, it may be approved. I don't know, does anyone know about this?
A digitization project?
Yeah. No, this is a successor to Charisma. Yeah, I found something about it once on the Prado's website, and I haven't been able to find it again. So, anyway, maybe they just dropped it. I don't know. Maybe it was just too controversial. I don't know. Thank you.
Thank you so much. Any other questions, remarks?
I just want to say that I think that this particular panel is very enriching the conference, because the first part was really Italian telling to for a foreign public what we think, what are our principles, and what is our philosophy, our rules. But when it comes to digitization, something new, something that is breaking new grounds, as Lucrezia said, and we like provocation also because we are at the end of the conference. Really, it's a dialogue that invites to reflect on ourselves. And especially, I will say, on the importance and the role we have for museums. Because and all of you paid a lot of attention to the speeches, I think that the word museum comes up a lot when we talk about Italian law of cultural heritage. But museum doesn't exhaust the idea of cultural heritage. And perhaps we should also think about the legitimacy of museums to be the only one that has the power to give the narrative about the cultural heritage that they have and that they regulate their use. So I think really digitization, it's a point in life when we, as Italians, have to rethink, have to bring back the dialogue and rethink about our institutions.
I'd like to add something. Thank you, Giacomo. I was really looking forward to this panel as an art historian too, and I want to spezzare una lancia in favore. And one of the most useful sources of information, strangely enough, comes from Bologna, and it's the Archivio Fondazione Zeri. And what would we have done without consultation of Federico Zeri's thousands and thousands of photographs that the University of Bologna digitized and put online for us, because now comparative stylistic research can be done easily. But don't forget that a lot of art historians in this room studied from books with colors in black and white, hardly readable. and we were always very anxious to see the original. And that's a little tip I'd like to leave to this conference, the emotional impact of the original. And so why make such a fuss over digitization when you stand in front of that night watch? I don't care how many times you can, copy it. The impact with the original is outstanding. Thank you.
Yeah. There's somebody.
Yeah, just to very quickly jump in, I'm so happy that you said this, because this is something that Aideen and I were just talking about a couple of days ago when I was sharing with her, again, another kid story, my desire to stand in front of the birth of Venus undisturbed for 1 minute, just so I could enjoy it and not have to negotiate my kids fighting behind me. And I was like, please, I work really hard. This is my work. Can I just enjoy looking at this painting? And my kids were like, no. But I will just say that no matter how many times I've seen reproductions, nothing compares to that feeling, right? And the aura, right, as Professor Sprigman has written about. I mean, it is this notion, and I think that that's why we need not be so frightened of digitization. If anything, it makes my desire to see the birth of Venus even greater, right, because I've seen so many digital copies.
That's the ultimate goal.
Yeah.
So I don't have an answer to this, but every time I go to a museum, I see young people taking photos on their phones of paintings. And I think to myself, this notion of the aura is interesting because it may be generational. So Walter Benjamin, writing before World War II, he's writing about a moment where the camera is becoming widely available, color film is becoming widely available to people for the first time, really, at the moment he's writing. And he hypothesizes that photographic reproduction of the painting tells the truth. And in telling the truth, it essentially draws the aura out of the painting and destroys its distinctiveness. And that this will be a trade-off. On the one hand, we won't have the same reaction to the work of art that we used to have. On the other hand, more of us will have a reaction. And so if you sum up all those reactions, maybe the sum of human welfare has gone up. Right now, he was a Marxist, and he believed that this is likely the case. Maybe I'm saying this as an old person who, believes that when I go and see a painting, I have a feeling that I never have, even with the Rijksmuseum's amazing reproductions, which I study and value. It doesn't seem the same. But maybe that's just because I'm older, and maybe younger people who are taking those photographs with their phone don't feel that way. Maybe this is just an artifact of human culture that, like a lot of things in human culture, is not forever and will pass. I think we'll see, especially as, reproductions become more immersive. So there's the caves and my French pronunciation is terrible, Lascaux, which are the caves in which some of the oldest cave paintings are found. And of course, people tromping through there all the time are ruining those paintings. So what is the French government doing? It's doing a real painstaking reproduction of every inch of those caves, which will be presented in an immersive environment where it's not done yet, but when you go into there, it will be much more real, in a sense, than reproductions usually are. I'm waiting to see what that's like. I'm going to go.
Thank you.
May I just add, the restorer again, and I'm also teaching theory of conservation. Already Cesare Brandi said, without materia, there is no image. I'm a restorer for paintings. So digitalization is very important for us. It's very, very interesting, but I agree very much what has been said before. The emotions that are related by standing in front of the real physical artwork is, for what I understand, and I'm middle-aged, is not coming by the digital one. But on the other hand, obviously, I understand how beautiful it is for people that cannot come to Florence, they cannot come to Amsterdam or wherever to see at least part of the artwork, or partly the emotions of the artwork.
Yeah, I think that one important aspect, apart from the importance of conserving, of preserving, and or offering an additional kind of access, which is not the same, because the aura is like not comparable. The Stendhal syndrome, you won't have it just looking at the and NFTs, for example. I'm just giving another provocative thing, but one important aspect related to digitization is not only, I think, replicas, reproductions, but reusing these digital images, so inspiring new ideas, making them available to create new works that can in turn be protected by copyright, for example, or they won't be able to dilute it, the symbolic and the cultural value of the original. If you see, I mean, we saw the David many times. I also have at my place 2 small of those statues that they sell in shops because I love it. But and also I would suggest a video from this Korean artist at the Biennale, at Venice Biennale in 2017, which is like 5 minutes video about David, and you can find it on YouTube, and you will be addicted. But I lost the track of my thought, but yeah, the fact is, if you will see all these different kinds of expressions, artistic, transformative, creative expression, even commercial, like commercial art. We saw many examples. You won't forget the original, especially for these kinds of artworks and cultural objects, and probably maybe you will feel more, as Marietje says, like inspired to go in person and to take a plane and to visit the museum or the place where it is.
I agree. We always say nothing beats the real deal. But on the other hand, as I showed the image of the night watch, when you can see it so, I mean, it's a different experience, and it's just as valuable, but it's different. And the one is more emotional, and the other one is more informative. But it's both very interesting, and I think it's all about open access and to be as accessible to the whole world as possible, because that's eventually what we want with our cultural heritage, that the people know about it and feel connected with it.
Just a final thought. I don't know if it makes sense, but it was coming to my mind right now. If we think about music, perhaps many of us today listen to very simplified music files that are compressed and lose a lot of stuff, Spotify, YouTube, whatever. And is it a worthless experience? No, we all enjoy, we all feel emotion by this. Nothing will replace listening live music, not only because you're there, they are playing, but also because of the complexity. The way the sounds will come to you, not through earplugs that mimic the bass waves that needs meters to develop, because you will actually be listening to real music. These are different experiences, but both have their importance. Perhaps this can be...
I had the same thought, because going back to Marcel Proust at a certain point in his life stopped going out, but it was a great passion to music, and at the beginning of 20th century there was no sophisticated reproduction, but he subscribed to this service, so he just opened his telephone on the night and he was listening live to what was going on at the opera in Paris. So that is the kind of, or I even think of, a disabled person that is not able to travel, and that is the only access that can have to certain masterpieces on the one side. But on the other side, I think maybe the aura idea that, it was already in my mind before I read Walter Benjamin, it's a generational issue. It's an old world thing, and maybe a digitarian, in the end, would prefer the perfect purity of a perfect digital reproduction. Maybe.
Can I on this? Well, I don't know. But in any case, for sure, a digitarian want to have more experiences. So just the same object, when you digitize that object, it becomes ontologically different. So this is the point, and you can experience that object, which has been digitized, in different ways by using, reusing. Just apropos, the Coro thing. Yeah, for example, students or younger generation digitarian, they say, what is this good morals, decoro things that it's for certain a censorship that cultural heritage institution try to put forward in confront of us. I mean, they say, why can't we use just to freely express our ideas, our thoughts? For example, one digital image of David or whatever, because the nude or the sexual thing is censored by public authority when you come to cultural heritage, for example. And moreover, why automatically Facebook, Instagram, and other platforms notice and take down and just close up your account and you lose everything? This is censorship. There are a lot of artists, young artists, they just, encountered all these things. So in their lives, think about performers. They are playing with their bodies today. They are transforming arts through their bodies in something living. They don't want to protect by copyright, in any case, all these things, because they say, okay, but I don't do that for copyright. Probably I do that for my reputation and because I enjoy a lot. So let them some oxygen, I would say.
No, there are some scholars in Italy now, especially who are just contesting that this idea of the quota also is against freedom of expression, and the fact that the Italian Constitution especially equates the creation of art and freedom of expression, even though, of course, you do have buon costume in Italy, like Daniela Manacorda, for example, if you look on Edon, has written an article about this. So I think it's a very live question and a live issue, and it's something that in the United States we grapple with also. So I think it's, as we continue to digitize and we continue to reuse and reappropriate, it's just going to be a tension that someone will need to answer, whether it's by ethical means or whether it's a court case, or so it's a very live issue.
Any other questions? Looking at the time, I think we should. It's perfect. I just hear it's perfect. Maybe next time we have a whole conference about this subject only.
Yeah, we just said the framework.
Thank you so much.
And without further ado, we take 5 minutes or we go straight to conclusions? From our conclusions? Conclusions, yeah. Yeah, I think it's best to go straight to conclusions because we keep the tension and invite Professor Graziadei and Professor Sprigman to the table, as well as Dr. Pessina and Professor De Luca as president, no? Yeah, as co-chair.
Thank you to our distinguished guest who accepted to deliver our concluding remarks and following the order in our program, I would like to invite Professor Christopher John Springman, Murray and Kathleen Breen Professor of Law at NYU Law School, to deliver his concluding remarks to our conference. Okay.
Okay, thank you. Thanks first to the organizers for inviting me. I must say I'm always pleased to be invited to Italy, but more than that, I'm pleased to be invited to a conference where so much work has gone into the organization and the framing of the questions here. I learned a lot about Italian cultural heritage law, and a lot of what I learned really surprised me in ways that I think I'll try to make clear here. So thank you very much to the organizers, and it's been a huge pleasure listening to so many people who had so much really interesting things, many really interesting things to say. So during this conference, we've heard a lot about the history of Italian cultural heritage law, how it applies, and the institutions that apply it. I want to add to the conversation by setting the Italian approach to cultural heritage into some global context. Specifically, I want to compare the Italian model of cultural heritage with the approach that has been taken somewhat unintentionally in the United States, which for reasons you'll understand, I'll call the Jeffersonian model. So on September 6, 1789, Thomas Jefferson, the man you see on the left, wrote from Paris to his closest personal friend, James Madison, who you see on the right. Madison was engaged at that moment in drafting what would soon become the U.S. Constitution. Though it stands as the longest letter Jefferson is known ever to have written, his September 6, 1789 letter to Madison is focused on a single question: whether one generation has the power to bind another. The question, Jefferson said, quote, seems never to have been stated on this or our side of the water. Yet it is of such consequence as to merit a place among the fundamental principles of every government. And on this question, Jefferson's views were firm. The earth, he wrote, belongs to the living and not to the dead. The living and not the dead. This meant, Jefferson argued, that the living generation owes no special allegiance to the laws passed by the previous generation. If we decide to keep those laws, that's our choice, but there should be no presumption that old laws should continue in effect. More directly relevant to the questions of culture we're discussing at this conference, Jefferson also argued that the present generation owes no special allegiance to the culture of the previous generation. He argued, for example, that copyrights should expire after what today we consider quite a short period, 19 years. He even declared that every constitution should expire after the same short period. Note that Madison did not take his friend's advice. In fact, quite the opposite. The American Constitution he drafted put the dead firmly in charge. Arguably the most difficult constitution on the planet to amend, the U.S. Constitution is replete, as we're seeing right now, with anti-democratic features. But set that all aside and focus on Jefferson's maxim, the proposition that the earth belongs to the living, which helps us understand the U.S. approach. Now, the Italian law we've been talking about at this conference is, of course, built on a cultural heritage model. As a lawyer, I don't understand cultural heritage laws as merely identifying and cataloging important historical artworks and other cultural artifacts. I'm sorry?
Maybe it's not open, the mic?
Oh my God, really?
But you have a powerful voice.
Yeah, well, okay. That's really bad. Now I'm too loud. okay, I'll go back. As a lawyer, I don't understand culture, not to the beginning. Cultural heritage laws is merely identifying and cataloging important historical artworks and other cultural artifacts. Cultural heritage laws take action by identifying and restricting the public's use of cultural property. This is done through some form of regulation or intellectual property rule. Cultural heritage law, as it works out in practical terms, almost inevitably involves cultural restriction. I want to contrast this with the Jeffersonian model, which understands culture not primarily as a thing to be protected, but as a thing to be used. This model, as Jefferson would have it, is concerned specifically with the interests of the living in producing today's culture, drawing upon the past, but also reworking it in ways that might preserve it or might destabilize and undermine it. This model is largely indifferent to, and perhaps in practice even hostile to, cultural particularism and to the stability of any particular nation's culture. In short, in this model, the first mission is not to preserve old culture, it's to encourage people to make new culture. Now here I want to emphasize two important points. The differences between the cultural heritage model and the Jeffersonian model are not black and white. These are models that overlap. Both see a role for preservation, both see an important interest in public access. But the two models place their emphases differently. We must also immediately acknowledge that one cannot argue that either of these two models is in some sense right or wrong. The two models grow out of deep differences in how we understand what leads to human flourishing. The cultural heritage model situates individuals within a particular culture, and it is based on the notion that some well-defined group identity is central to an individual's flourishing. On the other hand, the Jeffersonian model is both more cosmopolitan and more present-focused. Which is more attractive to you has to do with your underlying beliefs. Beliefs about the relative importance of individual autonomy versus group identity. Beliefs about the virtue of more rapid cultural change versus relative cultural stability. Reasonable people, of course, differ on these points, and I'm in no position to argue. That said, if you want to understand the Jeffersonian model, you could not do better than to look at this building, which has been pictured before. This is Monticello, the house that Jefferson at age 26 designed for himself. Or another building that you've seen before, this building. This is the Rotunda, designed by Thomas Jefferson for the University of Virginia. He designed and he modeled it on the Parthenon in Rome. You see that Jefferson is drawing, as of course the Romans did, heavily from Greek classical architecture, to which we might refer as part of Greece's cultural heritage. But Jefferson did not think of Greek classical architecture in those terms. In Greek classical architecture, he saw freedom and virtue and the power of human reason. But he did not think these characteristics were Greek or that Greek classical architecture in some way belonged to Greek culture. Jefferson was an Enlightenment universalist. He saw all of these things as the inheritance of humankind. Now, I have to acknowledge, as another speaker did earlier, that Thomas Jefferson surely did not follow in his own life all the principles he espoused. He was a universalist who wrote in the Declaration that we hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. And at the same time, he owns slaves. But let me leave off with history and turn now to the ways in which the different models cash out in terms of law, either law regulating cultural property or the absence of law regulating it. Note that I am not focusing here primarily on physical artifacts, although I think the case for cultural property in material objects is often more complex than some will acknowledge. I'll just tell a quick story to illustrate that. The story will also move us along to the question I'm most interested in, which is how cultural property frameworks should think about intangible cultural goods. Okay, so back in 2018, I received a call from an American artist with a legal problem. The problem was related to some artworks the artist created based on pictures of this, a Neolithic ivory sculpture called the Venus of Brasompuis. This picture of the Venus sculpture that you see here depicts something that was carved about 25,000 years ago from a piece of woolly mammoth tusk. It was found in a cave outside the small town of Bois-Saint-Puy in southwest France. It's now on display at the French Archaeological Museum near Paris. And here's a picture of what the artist Ana Maria Garza did with it. Ms. Garza wanted my help because a representative of the French National Museum of Archaeology has emailing her demanding that she stop selling her artwork. Use of the image of the Bois-Saint-Puy Venus for commercial purposes, the museum representative said, was an impermissible use of cultural property and was against French law. I wrote back to him, telling him as politely as I could that he had no claim whatsoever in an American court, and that if he did file one, we'd seek to hold him responsible for Ms. Garza's lawyer's fees. I never heard back. So, is this artifact the cultural property of France? I think the case, to put it carefully, is weak. Other than the fact that the sculpture was found in a cave that's located barely within the borders of the modern French state, nothing about the artwork would make it specially relevant to French culture, as opposed to the culture of any other nation, or indeed of human culture as a whole. Think for a moment of the name we give to the sculpture, the Venus of Bois-Saint-Puy. Venus is a Roman name for a Greek goddess. The name speaks to the fact that the sculpture, and more importantly, the way we see it, is at odds with any conception of cultural heritage based on national identity, which I think Jefferson would have understood. Obviously, the 25,000-year-old Venus of Bois-Saint-Puy is a polar case. Less ancient artworks are more identifiably or justifiably identified as the heritage of a nation, and as we understand that term now. But where is the dividing line? At what point does the antiquity of an artifact begin to make identification with a nation, which is a modern conception, more difficult? So I want to circle back to a question I raised yesterday. Is Giovanni Bellini, to take a prominent example, an Italian painter? Or is he a Venetian one? Or is there a reason to think that Bellini is part of a wider cultural heritage that flows across national borders, as Jefferson believed Greek classical architecture to be? As best we can tell, Giovanni Bellini was born in Venice, spent all of his 85 years there, and never traveled further than Mantua, which is less than 160 kilometers away. You might respond that Bellini's localism doesn't matter. If Bellini is a Venetian, then the job of the Italian government is to protect his works by anchoring them down in Venice. But that doesn't entirely answer the question either, because the problem isn't only about geography, it's also about time. The man depicted here, Leonardo Loredan, my pronunciation is appalling, and I apologize for it, was one of the most consequential doges in the history of the Venetian Republic. An inhabitant of 15th century Venice would have understood Bellini's portrait through the lens of Loredan's political career. In particular, Bellini's Venetian contemporaries would be familiar with the decisive role the Doge played in preserving the Venetian Republic in two wars that had potentially existential consequences for the city-state. The first was against the Ottomans, the other against the Pope. Under the Doge's skillful and altogether ruthless leadership, Venice was able to negotiate a peace treaty with the Ottomans and to keep most of the papal lands it had earlier seized. In the Doge's discipline and canniness, a 15th century Venetian would see a reflection of Venice as understood and promoted to the world by the Venetians. Now, we must ask how a modern Venetian would understand this portrait. Surely as a beautifully executed painting, but does it speak to the modern Venetian as part of his or her cultural heritage? Loredan's Dogeship and the wars he fought are deep in the past. Of course, the consequences of those long ago struggles are still relevant in some way, but the consequences are likewise relevant, I would argue, to everyone in the West. The Venetian Republic's struggle against papal authority, for example, was just one theater in a broader European struggle, sustained over centuries, often spectacularly violent, which pitted secular against religious authority. And of course, those struggles fed politico-religious conflicts that sent waves of Italian immigrants and European immigrants and refugees to the New World. So in this web of interconnected historical and political threads, whose cultural heritage is Bellini, Venice's surely, but also Rowen's, and Amsterdam's, and Hamburg's, and New York's? This tendency to equate cultural heritage with national heritage is a blunt way of understanding any of the important questions that cultural heritage raises. That equation tends to underplay the ways in which, at least in the West, particular artworks and artifacts are drawing from and contributing to intellectual currents that are flowing across European borders and to the New World, either the borders we knew at the time or the borders we know now. My takeaway here is that even with respect to tangible cultural artifacts, the foundations of cultural heritage law based on national heritage are shakier than they may appear at first to be. This isn't to say that nations don't have reasons to promulgate and to enforce these laws. The presence of artistic treasures on a government's territory is part of the government's prestige. And when it becomes a focus of tourism, art is an economic asset. These are all perfectly valid interests that support rules about the disposition of tangible cultural artifacts. They probably don't support as pervasive a set of rules as the Italian system imposes. These difficulties deepen when we turn to intangible cultural heritage and the cultural property rules that cover intangibles. Here you see two packets of cheese, one from Greece and marked feta, the other from Bulgaria. I took that picture in my local grocery store and marked quite unhelpfully Bulgarian sheep's cheese. I say unhelpfully because the Bulgarian cheese was until quite recently marked feta. And that is a defensible label for it, given that, like the Greek cheese, it's made of sheep's milk, it's made by the same process. For hundreds of years, it's been made in a region of Bulgaria that borders Greece, where many of the people are ethnically Greek, and where they speak the Greek language. It is a branch of cultural heritage law that forced the Bulgarian cheesemakers to relabel their cheese. That law is the International Regime of Geographic Indications, or GIs. GIs are source identifiers akin to collective trademarks that designate a given geographic location as the sole legitimate source of a good on the basis of a conclusion, really more of an assertion, that a particular good is part of the cultural heritage of the particular place. Well-known examples include Bordeaux for wine or Parmesan for cheese, and the notion roughly is that some combination of the physical characteristics of a region, which people refer to as terroir, plus local knowledge yields distinctive products that cannot be replicated. Use of the name with products from another location, this line of reasoning goes, is simply misleading consumers. And this is why we see the Bulgarian cheese labeled in a way that makes it difficult for consumers to understand what, in fact, it is. Now, there are many conceptual and practical difficulties with the protection of GIs. First is that the empirical evidence for the centrality of terroir is, to put it charitably, thin. Of course, soil and climate contribute to the taste of wine or cheese, but the idea that a particular terroir is unique, that it cannot be replicated anywhere else in the world, would be a surprise to the Portuguese immigrants who, since at least the 16th century, have been making quite spectacular port wine in South Africa's Western Cape region. You see here on the left an older bottle of South African port and a newer bottle of so-called, quote, Cape vintage. This name change happened because the Europeans forced it in 2012. And as with the Bulgarian cheese relabeling forced by Greek claims of cultural knowledge, the South African wine has been relabeled in response to Portuguese claims of cultural heritage. It is important to note that for wine and spirits GIs, the legal prohibition is not simply against false identification of the geographic origin of the wine in the bottle. The prohibition extends to comparison or reference. It would be illegal, for example, for the South African producers to refer to their product as Cape Port, or even port-style fortified wine, even if the producers use the same grapes and methods traditional to the Loire region of Portugal. Now, one suspects, if one is a cynic, that the broad scope of this prohibition is not really about cultural heritage. It's about the desire of traditional producers to limit competition. It's perhaps not surprising that the Europeans who have worked to enforce these rules upon the New World, and the New World has resisted. To be clear, all GIs do is bar the use of certain descriptive words or place names. They do not bear the mimicking of style, taste, or appearance. So in other words, a wine called Chablis, but not made in Chablis, runs afoul of the GI rule. But nothing stops a winemaker in Australia from making a wine that tastes like Chablis, and in fact, they do. GIs just mean that they can't call it Chablis or employ the name as a comparator, like Chablis style. The result, as you might expect, is consumer confusion, which is precisely what the law claims it is trying to avoid. The confusion is created by, and indeed is intended by, this branch of cultural heritage law. Now, I think it should be clear, if I had my way, I'd scale back these rules substantially. I would, at a minimum, permit competitors to use the place name to compare or refer to the traditional product, to inform consumers, in other words, that the South African fortified wine they're looking at the wine store is in fact something that will taste like port, which, however forcibly the proponents of terroir might insist otherwise, is basically true. I want to close by talking about another aspect of resistance to cultural property, and you might recognize it in this piece of American cultural property. It's an interesting and at the moment timely case. The copyright term in the United States, as in the EU, is the life of the author plus 70 years. That is, to be blunt, absurdly long. A term that long is, in terms of its present economic value, barely distinguishable from a perpetual term. The US Constitution specifically forbids perpetual copyright terms, providing that copyrights may be granted only for a limited time. And yet in a 2003 decision, Eldred versus Ashcroft, the US Supreme Court permitted Congress to lengthen the copyright term from life plus 50 to life plus 70 because, said the court, even though the longer term is nearly perpetual in economic terms, it is mathematically finite. Okay. So let me show you a picture that illustrates the cost of cultural heritage in the form of very long copyright terms. This is taken from a study by my friend Paul Heald that looked at the number of books offered on Amazon, counted in terms of titles available from a particular decade. So titles from the decade of 2000 to 2010, titles from the decade 1990 to 2000, etc. The shape of this graph is not what you might expect. Why are there more titles available from the decade 1910 to 1920 than from the decade 1980 to 1990? Copyright is why there are more titles available on Amazon from that old decade. Why? For brand new books, as of the time Paul did his study, these are the books in print that copyright has incentivized the production of. But for somewhat older books that are no longer commercially valuable enough for commercial publishers to publish them, they stop being published, which means they stop being available on Amazon. They're available in some notional sense. They're buried in libraries. They're on the dusty shelves of used bookstores, but they have been submerged. So what does copyright do in kind of provoking, the production of new works? It does incentivize new works at the cost of a lot of our recent past. Now, it's not that our recent past isn't valuable, because look what happens when copyright runs out, which at this time was 1923. The availability of titles jumps up. So these books are valuable. They're just not valuable enough to have a commercial publishing house commit resources to publishing them. Although, when you no longer have to pay royalties, suddenly they reappear. Okay, so what does this mean? Well, let me turn back to our friend, I guess. His copyright, or more precisely the copyright in the original version of him, is set to expire in 2024, which raises the question whether we should continue, after copyright expires, to regulate Mickey Mouse as a form of American cultural property, which surely he is. The Supreme Court's already answered that question, and the answer is no. In 2003, the same year it approved longer copyright terms in the Eldred case, the Supreme Court decided another case, Daystar versus 20th Century Fox, which is arguably of greater long-term consequence. In that case, the court inquired into whether an artistic work for which the copyright term had expired could be protected perpetually by trademark law. That is, protected on the ground that people had come to recognize the work as coming from a particular source, and that allowing it, therefore, to be reproduced by competitors would confuse consumers about the source of the product. If you apply that concern to Mickey Mouse, it's pretty clear at this point that people identify the image with the Walt Disney Company. If we apply trademark law, Mickey would be protected by the law as cultural heritage even when the copyright term had expired. The Supreme Court said in the Daystar case that trademark doesn't work that way. The court noted that the Constitution requires copyright terms to be limited and that it would not interpret trademark law in a way that would prevent artistic works like Mickey Mouse from falling into the public domain. I shouldn't say falling, from moving into the public domain. So when Mickey's copyright runs out in 2024, the mouse will be, as the great Justice Louis Brandeis once put it, free as air to common use. Although the Daystar decision has not been understood this way in the US, it is, I'd submit, a decision about cultural heritage. It is, to be more precise, a decision that permits the public to access an important part of America's cultural heritage if they wish to exploit it and even to destabilize it and to subvert its meaning, which I can testify many people are ready to do. The decision thus reinforces the skeptical American approach to the entire enterprise of constructing cultural heritage through rules about cultural property. Our nation's cultural heritage is, to borrow a phrase, for the living. With that said, let me end this speech by returning to a story from America's founding. The man on the left you've already met, that's Thomas Jefferson. The man on the right is John Adams, one of the most important figures in the founding and the second president of the United States. Adams and Jefferson were what we today in American slang would describe as frenemies. It was Adams who persuaded Jefferson to take on the task of the Declaration of Independence because Adams later said Jefferson was a much better writer. They later fell out over party politics before reconciling later in life. In a coincidence that seems almost too perfect to be true, both men died on July 4th, 1826, precisely 50 years to the day after the signing of the Declaration that Adams had provoked and Jefferson had drafted at the risk of both their lives. And on his deathbed, more than 500 miles north of the bed in Monticello, where Jefferson lay dying, Adams' last words were, "Jefferson lives," which was wrong. But in another sense, it was right. In America's approach to cultural heritage and cultural property, Jefferson lives. I'll stop there. Thanks.
Well, thank you for this fascinating, thought-provoking conclusion. And now I will leave the floor to Professor Michele Graziadei at the University of Turin. You want to? Okay, you have.
Thank you. Alessandra, thank you. This has been a wonderful conference, far exceeding my expectations. Andrea next to me told me they got you in trouble because you have an impossible task. I agree. So I have not prepared a structured speech for you, but I will just offer some sparse remarks, thanking the organizers once more, and especially my friend Vittoria Barsotti, who has been in the backstage, in a way, coordinating this splendid team that hosted us and gave us so many interesting thoughts. Of course, I'm also very grateful to all the institutions that participated in this conference and tremendously enhanced its scientific value. And thinking of it, I think that if a volume will produce, and I'm sure it will be produced, it will be once more an outstanding contribution to the state of the art. I have just listened to the concluding remarks of my colleague John Springman that started sketching a comparison between our experiences, and I just want to address a couple of points that he made before I forget them, because I'm quite tired by this time of the day. And the 3 points are basically the question of whether one of those great masters, say the one from Venice, what is the title of the Italian state to do what it does with that cultural heritage as an obvious answer, and it's a legal answer. The Italian state is a successor to the prior states. So in legal terms, nobody ever thought that something was illegitimate with our cultural heritage law. So from the purely legal, but I will return to the deeper point, question, we cannot change this answer. For all the states in the world, we have to accept that we are living in such a landscape. And I'm sure you don't want, Mexico to ask about Texan cultural heritage law, given the fact that once, and so on and so forth. But I'm sure. So that's my first provocation. The second one is the following one. I think you're right in identifying the spirit of US cultural law. I think there's an undertext to this, and I will come to it. But first, let me remind you that only the US had such a perverse idea as starting originalism as a way to interpret the Constitution. In Italy, we may be fixed on cultural heritage, but when it comes to the Constitution, we took a different line. Perhaps, we have something to learn there. But for the moment, I don't see our constitutional lawyers turning to originalism. And this for good reasons. In a way, it was a revolutionary constitution for our country. Yours as well, but with a deeper history, for sure. Last point, which already brings me closer to what I have to speak about, it is obvious that one of the watershed is the role of the market in this context. And this is the subtext, in a way. I will turn to this, but before turning to this, I would like to start from where we started. That is to say, in order to have a dialogue, you have to have a common set of words, and you have to have a common set of concepts. Otherwise, the stumbling block begins there. And in this, I want to give you a slightly different message from the message that, at the first, a slightly different message pointing to what is common among us, despite the apparent differences in languages. And here I have to, to call the attention of our Italian friends to the work of the late Professor Sachs, that was from California, wrote extensively on cultural property. He published the book Playing Darts with Rembrandt. And basically, he said, look, he was also an expert on water law. We have to realize that there's an element of stewardship when we start talking about cultural property, and there's also a sense of obligation to the community, which has always been there, to the point that the modern notion of property right, and here we are sitting in the room of the Department of Legal History of the University of Florence, the modern notion of property is not quite in line with the understanding of that cultural construction, which is owning cultural property. And of course, the doctrine of stewardship relates to the notion of trust, and trust law is always there in a sense, because we speak of trustees sitting on a museum board. They have fiduciary obligations. It's a form of property that is distinct. And it is important to understand that this form of property is not different from the notion of tutela that we meet when we start studying Italian law. Actually, if we want to go back, Basically, these are notions that have common roots in the intellectual landscape of the protection of the person. We didn't develop the trust as such, as a legal instrument. Tutela was our way. Your way was the trust. The trust law is immensely important in organizing the management of wealth, and also in terms of preserving that wealth, possibly for future generations. Charitable trusts are the most obvious example. So we do have some common grounds that we tend to forget simply because the pattern of language is not necessarily uniform, but behind that, the concepts may have some unity. Now, if we move beyond this, we have to recognize that the Italian narrative about the protection of property is skewed. In which sense is it skewed? We have all mentioned the papal bulls and the documents, the historical documents that lead to the notion of protection today. Let's remember that basically these documents were concerning the prohibition of pillage. So basically they were protecting in terms of saying, look, stop stealing those marbles. But if you think of it, this is only a part of the story, because for sure there were legal tools in order to protect wealth in a way which was completely different. We had fideicomissa, for example. And if you think of it, much of what we see around our towns comes out of devices that were the typical patron-client device. Every testament in the early part of the the 12th century, 13th century, and so on, had a legacy pro bona oblata. What does that mean? They were practicing usury. Usury was forbidden by the canon law, but the merchant did it anyhow. So in order to clean their hands, a part of the wealth had to go to the community. You all know the story of Fondazioni Bancarie. Fondazioni Bancarie get their money from the community and must return to the community. And this is an interesting part of the Italian story. That is to say, we have the market, but through this Fondazioni Bancarie, I don't know if you are all familiar with this part of the story. They were created after the privatization of the banking sector in order to avoid a complete privatization of the sector. Politicians have their voice in it, for sure. We are in Italy. Once more, we have a public-private partnership there. So if we really want to reconstruct the history of Italian protective legislation, we should stop just, we should stop considering as the key feature of the story these protective pieces of legislation, because they are just a part of the picture. Much of the patrimony we have was constructed through private collections that were managed with tools that would be perfectly familiar to a modern US museum today. They were part of the family wealth. They were that type, and there was also the community part of it. Now, this does not mean that I don't sympathize with my friend, because we have to think that we entered into a completely new framework, and that is to say the presence of the state, of the Italian state. All of this at a certain point stopped. The Ancien regime went away. These families had their own troubles in negotiating with the Italian state. Some of the fideicommisse had to be turned into something else, although some collections in Rome are still under that type of regime. If you visit some of those collections, you will realize you are entering into the Ancien regime. The negotiation was not completely successful by the Italian state. But in any case, the Italian state was the successor to all of this. Not completely, because of course, purely private institutions are still there, and the church patrimony is still there. And that is part of the story, not completely Italian, to return to your point, the patrimony. Now, I still like to remember that, for example, the Palazzo del Quirinale, to my students, is the former palace of the Pope. So the Pope does not really like going there to pay a visit to the President of the Republic. It doesn't usually go there. So there are a number of legal issues, very complicated legal issues related to this story. But when we enter in this new scenario, we have to ask ourselves, what is the Italian state, after all? This is a question that we seldom put to ourselves. It's two things. On one hand is the Italian Republic, the community of us all. We are part of this community as Italian citizens, and we recognize certain values and symbols that are attached to the Republic. On the other hand, it's an apparatus. It's the soprintendenza. It's all of this. They have a terribly difficult task. They are one of the few corps of the Italian state that can still claim to maintain the highest standards, as far as I can tell. I have never met a superintendent that was not an intellectual, in the fullest sense of the word. And I want to pay tribute to this, because I know how terribly difficult it is to maintain this position like this. They are like soldiers without the generals behind them, because if you go to the center of the apparatus, the only thing you can do is, look, Franceschini, why don't we try this and that? But in principle, the Italian state as a central administration does not itself have enough projects, does not itself have a vision for this. It's the soldiers that in Italy are fighting the battle, one by one. This is my impression. We're getting better. I'm not saying that we are going down. On the contrary, I think we are getting better. But perhaps the answer from the front is different. Perhaps from the front is different, but we have to recognize that we have nothing like the US federal state behind us, nothing as powerful. And this is the story of the Italian state. And this is why the genius of the locality in many ways is so important in Italy still, because the willingness of the local administration to fight the battle despite the scarcity of means is important. Now, having said this, I also want to add a few words about the fact that we should not demonize the experience of countries that, like the US, have given to the market a major role in doing things. We should not demonize it, because it would be stupid to demonize it. I still remember Levi-Strauss' essay about Santa Claus being burned as an heretic in the 50s, you know, as a sign of anti-Americanism. The arrival of Santa Claus in France was stigmatized as an attack to Christianity, and it was thought to be a sign of the imposition a sign of the, dominance of U.S. cultural values, because some kids were, having fun with Santa Claus, or Halloween today, that has arrived in Italy all of a sudden, and we have Halloween, I think this, as Lorenzo Casini said, would be an ideological move. We have to reflect on the US experience and of the experience of a number of countries that are allocating to the market a major role. I don't think that Italy is ready to go fully in this direction for the reason that I have just mentioned. Contrary to what it seems, that is to say, the all-powerful state we are relatively fragile. And this is why the reaction is so strong. Don't push in this direction, because we will not be able to negotiate seriously with you. We'll be in difficulty as public functionaries. So we have to rely on smart lawyers like Mr. Abatista in order to find the right way to do these things. These things are possible. We have learned this throughout what we have explored, but they must be done with the right level of expertise by the Italian state. I will put you a simple example. All the Italian local administrations at a certain point started buying swap contracts that were placed by by Goldman Sachs and whatever to the Italian to the city of Torino, to other cities, claiming that in this way they were hedging against monetary risks. It was a total disaster, of course. Those operations were clearly not at arm's length. There were problems, and the capacity to negotiate these things with the private sector is a big problem. Of course, here we're speaking of donors and not exactly people that are trying to selling you things. But, you know, since the history of Troy and a certain horse that was presented before the walls, you know, once it's in the walls, you don't know what it will be in there. Let me put it this way. Now, on the other hand, I must say that by now, several Italian institutions, I think, have this capacity. It would be something to consider as an opportunity to start working in this direction. Nonetheless, having said this, I still think that the role of the market and the role of the non-market sector, let me put it bluntly like this, is something that should be discussed in a principled way. This is not a problem that we just encounter in the field of cultural property. Blood donations, organ donation, to speak of the strangest topics in relation to this topic, are things that we have to discuss. What is reproductive rights and so on and so forth. Having said something that sets these two worlds apart, I also want to say something that brings them much closer. And that is to say, yes, the US have these museums that are by now in the circle of, you know, the world class of museums. And in a sense, they represent the culture of the entire world. But the US, the museums of the US have also institutions that represent something which is much more attached to local history. We heard the story about the controversy of the monuments linked to slavery. It happened to me to visit a mansion in Louisiana that was the site of a cotton plantation that was, of course, owned by a slave owner with the barracks and all of that. That is much more similar, in a sense, to a chapel here. That is part of the local history, and you cannot try to reproduce that over here by bringing a few models of those barracks over. So the US is presenting itself to the world with these wonderful and very important institutions, but all of you coming from the US, you know that if you go to the locality, to the small local community, you would find a sense of local history that is completely different from the one that you get by visiting one of those big institutions. These big institutions must live, but they will live amidst a lot of legal problems by now. These major global players precisely because they wanted to play global. And this is why nowadays they have to, reflect on ethical principles. We Italians are beginning to discover these problems. We had to return to Ethiopia, the obelisk that was standing right in center of Rome. And our anthropological museums start facing requests for repatriations by a number of countries around the world. Even in Torino, there's a case like this. The Dominican Republic is asking the return of a gift that was given to an Italian captain that fought for the Dominican Republic, of an artifact that comes from a cave in the Dominican Republic. The gift was legitimate by that time, by a legitimate authority, but nowadays nobody thinks that that authority could give the gift, even though it was legitimate by that time. So I think that although the US is forcing us to reconsider market dynamics in this context, a part of the history of the US is not really like that. Is not part of this global discourse over the circulation of works of art. Having said this, I also want to add that, of course, what could be the landscape of Europe if some of our paintings had not gone to Amsterdam, to England. Do we want them back because they were from Italy? No, they must stay there. They are representations of our culture. The Gioconda at the Louvre, fine. I don't think we want it back at this moment. So it is true that Europe is made of these encounters. And if we had, in the 1500s, a nationalistic approach to cultural property law, probably we would have not had a flourishing of European culture that was allowed by this very intense circulation of intellectual artworks. So I think that we must be very conscious of the fact that not completely agreeing with a market approach to the circulation of work of arts cannot mean denying the value of the intellectual exchange over all these things. And with this line, I will close, and I will thank you so much.
And in the spirit of this conference, which is based on dialogue and on speech, Professor Springman would like to add some remark to his concluding remarks.
Just one thing about last night, which I really appreciated. We were all up at the top of the hotel, and there were two Italian gentlemen playing music, and they were playing blues, exactly, which is a piece of American cultural heritage. It's a very valuable piece of American cultural heritage, along with jazz. And what's interesting about this, because you talked about the diffusion of works of Italian art into the European continent during a period where, well, it went on for a while, including Napoleon's depredations. But what's interesting about blues and jazz is they have always been international. And one of the reasons they have always been international is a lot of the people who were central in blues and jazz were black, and they were persecuted. So they fled. They went to Paris. They went to other places. And the result of this is that those music forms are as meaningful to many Europeans and many Japanese who are jazz crazy, as meaningful to those people as they are to Americans. And not just meaningful in a shallow way, I mean meaningful in a deep way. Because when I listened to those men last night sing, I recognize something, that I've recognized before, which is the pain, right, that blues, in a sense, leverages for artistic purposes is felt by people everywhere. It just happened to be, that pain happened to be expressed in a certain way by black people in America at a certain time. Now, what that really suggests to me in terms of protection of a nation's cultural heritage. So sometimes I think you know, Rome, in a sense, was protected by Constantinople, right? Long after Rome had been sacked, Roman culture in a different form was alive in Constantinople. Maybe one day, long after blues has passed away in the United States, it will be protected in Florence. There'll be something about these two guys in Florence that preserves this form. You know, part of protection is use. Part of protection is keeping something alive, not locked away in a museum, but actually in use by people. So that's all I had to add. The other thing I want to say is I am not an originalist. In fact, I am a very strong anti-originalist in writing, and I want to be understood. The other thing is, you know, I do not question at all, as a legal matter, the Italian state's legitimate position as successor to the different parts of Rome that were united, different parts of Italy that were united. What is important to me is not so much the authority to do what is done, but the reasons for doing what is done. You know, look, there are different approaches to thinking about this, and again, I just want to repeat, none of them is clearly right or wrong. They are based in different preferences and different commitments. You know, stand in the shoes of someone with different commitments for a moment, and you get a very different view of what cultural property should be. Thanks so much. I appreciate it.
I don't have a conclusion because I didn't know what I have to do. So I think the best is to share some consideration I was doing. I start from the end. During the last panel, I was really terrified about the digitalization because I was thinking, I have so many problems taking care of the originals, and now I will have problems also for the digitalization. I think we have, of course, it's wonderful tools, digitalization, but I think we have to reflect also about the risks of a digitalization. For example, not here, no speaking between us, we are experts, but thinking about the public, the big public. I mean, I imagine two Chinese, nobody's Chinese here, okay? I imagine two Chinese speaking, how many times did you visit Uffizi? 20? 20, really? But you've never been in Italy? Yes, but I have a digital tour. What does it mean? It's a little bit dangerous to separate the object from the context. The context is also the city. The context is also the landscape. Don't forget that archaeological finds and historical objects are also for us beni paesaggistici, are elements of a landscape. And this is really important. I have to think about the Arno River to Ponte Vecchio as something like this to put the things in the correct context. If we've digitalized too much, maybe for some people, the risk is to forget the context. And usually when we speak about digitalization, we think always about the art object. But for example, for archaeological things, digitalization is useful, but it has big limits. I mean, I can reproduce a shape of a pot, an ancient pot, but for us, for example, I am an archaeologist, it is interesting also to analyze the clay they use to produce the pot, because I can understand if it is imported or not. It is useful to analyze the lipid, I mean, some traces that are inside, and they can tell me for what it was used. I mean, there isn't an end to study an object. This is why in ancient times when we find human bones, they put inside in the ground. No, not now, because science is developing. Now we can do the DNA analysis. We can do analysis of the teeth to understand the paleo diet. So I think this is one of the problems. I was also thinking about the next topics for the next conference. Oh, really? For example, Professor Graziadei had maybe the same idea. The problem of repatriation of the object. The major case is the Elgin marble, of course, from Partenone. But it is always possible to come back these things, or, I mean, there is an expired date for the repatriation. Because now the Elgin marble are also part of English culture, London culture. So now they are property also of English people. So, and if maybe it could be a good exercise, what's happened if we start to repatriate all the objects they were stolen, and now they are exposing in the European Museum. So I think, or maybe another, I think another issue very interesting is the destruction of a cultural heritage to destroy the cultural identity. I participated many years ago in Cairo in a conference, and it was the theme was the illegal trafficking, but it was also the ISIS was destroying all the things everywhere to destroy the cultural identity. Or maybe also this one Professor Graziadei told about the use of cultural heritage to create a new identity, especially now that we have to face with the nationalism. This is a bad use, but there is the risk. Of course, during these 2 days, we have spoken about only the movable objects. But don't forget, especially for Italy, there is also landscape. And I think that also landscape, it is an issue really interesting, especially to compare the European countries and what's are happening. Unfortunately, maybe nobody knows, at the beginning of this year, the article number 9 on our constitution changed. Now they put another comma, I don't know which is the name. I mean, cultural heritage is very important for the development of the nation, of Italian people, and now they put also, it is also important, the protection of the environment and the animals. So everybody say, wonderful, but we are really worried about. Why? Because in this way, cultural heritage is not the first place, but there is something behind, accanto. Okay. And what does it mean? It means that maybe the superintendents, I have to authorize a railway, a new railway, or a new airport, or some eolic system. Windmill. Why? Because they said, but we want to build these things because in this way pollution go down, and it is to save the environment. And not only the superintendents, but also many lawyers. I remember Giuseppe Severini, it was the head of a state court, it is very worried about. Though, I don't take more time. Maybe the proceedings of this conference we can speak about. Yeah, of course, we want to publish as soon as possible the proceeding. In our rivista, it's a book. In our bulletin, okay. We hope to print, maybe it's too early for the end of this year, but we will speak about, so don't be afraid. But we're ready, okay.
I would like to thank you all for being here, speakers, attendees, and I hope to see you all again for the next conference in this, I hope, a long series on cultural heritage. Thank you.